Thank you. You may be seated. Good morning. I am Judge Faruya. To my right is Judge Campbell, and to my left is Judge McMurdy. And we are here for oral argument in our case CV22-0004, Atkison versus Shafer. As you may know, we record and live stream these proceedings, so please give your name and the name of your client prior to beginning. You have a maximum of 20 minutes per side, although you are not required to use all of that time. The clocks in the podium are there for your benefit to help you keep track of your time, which you are responsible for. You should know that the time kept inside the clock is inclusive of any time that you wish to reserve for rebuttal, which you are also required to keep track of yourself. So we'll do our best to accommodate that if you let us know, but that clock does keep that time as well. Please keep in mind that we have read the briefing, we have studied the record, we have discussed this case in conference, and with that, you may proceed, counsel.
May it please the court, my name is Mark Shields. I am here on behalf of Diane Atkison, who is present. This is David Goldfarb, who was trial counsel. Not all facts are created equal under Title 25. I'm speaking, of course, about facts that give rise to legal presumptions and therefore present legal issues to this court. These facts, when they are presumptions, place a burden on father, not on my client. Frankly, it would be very difficult to imagine more compelling facts for a case under ARS 25409 than this case. Yet my client received no relief whatsoever, and the ruling effectively severs the minor child from the only stable parental figure he had had. Why are these facts so compelling? I want to be clear, I'm not speaking about disputed facts. I will try to make it clear when I'm talking about disputed facts if they come up, but no, the vast majority of what we are talking about here today are undisputed facts that give rise to not one, but two separate legal presumptions, both of which were treated improperly. When we have a case involving legal presumptions, as with this case, the legislature essentially creates a map.
Okay, before you go there, I want to clarify something with you. I'm looking at 2540303D. This is the presumption in the domestic violence area. And it says, if the court determines that a parent who is seeking sole or legal decision making, this parent technically wasn't seeking sole or legal decision making. He acquired his parental rights based on the fact he's the biological parent, right?
He acquired parental rights, but those are, of course, subject to the statutory scheme.
Okay, well, it says a parent who is seeking. There wasn't a parent who was seeking, it was your client who was seeking, right?
It was my client who was actually awarded at that point, but yes, there is still a dispute.
She filed a petition which would indicate she is seeking.
Correct.
He never filed a petition. He had earlier, but that had been dismissed. So he was not seeking legal decision-making or parenting time.
His position was clearly that of seeking. Whether we get into that through through filing a formal petition, the result is the same, because I would point the court to the rest of ARS 25403, which clearly points out that domestic violence is not in a child's best interest, that the trial court shall take evidence of domestic violence as contrary to a child's best interest.
No, to me the issue is whether there is a presumption here, because they're competing presumptions. The presumption in 409 is the legal parent, which he was. Your client had to prove by clear and convincing evidence, right?
Correct.
So when we're looking at the different presumptions and the burdens, it matters who is seeking what. And your client was seeking a parental order for legal decision making.
Correct.
Okay.
And so was he, because he was looking for that.
No, he did not file anything. He didn't have to.
Nevertheless, it was his position. When we are dealing with cases with these major issues, again, the legislature essentially creates a map. The legislature says that this is where the court is required to go in the absence of certain rebutting and mitigating facts. But when the trial court in this case held that domestic violence was irrelevant, It didn't even get into presumptions. And the court, obviously, Judge, you know, I made two separate arguments regarding domestic violence. But when the trial court holds that domestic violence is irrelevant, the court went straight off of that map, and it never recovered. Why? Because there's no
Counsel,
evidence disputing.
is it really true that the court said that it was irrelevant? I mean, didn't he say that we need to consider those things? So it's not that we don't consider it, we do. So isn't it, and you keep talking about, okay, the legislature sets a map. That is absolutely true. But maps, like any sort of guide like that, depend upon context, don't they? I mean, how useful the map is also depends upon where you're going and where you're trying to get to. So where you start from, isn't that a relevant question?
I'm not sure I understand. Where do we start from in terms of what you're...
Well, this goes back to what Judge McMurdy was saying. Who is seeking? Who has the overriding burden?
Well, frankly, the answer to that case comes from the Olson case that I cited as supplemental authority. That case does, in fact, apply these presumptions, or at least the presumption of domestic violence.
Well, okay, but he was seeking, because he filed the petition to modify in Olson. The parent in Olson filed a petition to modify, so he was seeking in that case. But aside, I agree with you that the court has to nonetheless consider domestic violence. That is a separate issue on whether there's a presumption.
And to Judge Faruya's question, the actual words of the trial court are, the court concludes that father's history of domestic violence with mother, which was sometime mutual, is not pertinent to the current dispute. Not pertinent, irrelevant, I'm using synonyms there. I have pointed the court to the Christopher K. case, in which the court reversed a trial court decision because some of the facts that were set forth in that case could amount to domestic violence. This case goes far beyond potentialities. We have actual convictions. And for a judge to claim that it is not pertinent is simply an abuse of discretion. The court is off of that map. The court committed what is clearly an irreparable error, as this was the first of its findings. The court, as I said, never got back to the map after that. I would point specifically...
I'll go with you, counsel, in as far as saying that he said that the issue was not controlling. But I don't parse that language as saying that it wasn't considered. So, like for instance, presumptions are rebuttable, are they not?
They are.
Okay. And if you look at this in terms of what your client's burden of proof is versus what father has to prove in order to determine that his continuing parental rights are in a child's best interests, you can harmonize those, can't you?
Not under the facts of this case, because there is no evidence that he rebutted it. There was some mention made in the opening statements that really were opening arguments that he had attended certain classes, that he had taken some steps to address his problem. That evidence never came in. That evidence was never disclosed. There wasn't even testimony about that. So there is no evidence rebutting it.
Mr. Schultz, when was the last, what you would say was the last act of domestic violence committed by father in this case?
That we know of, I would point the court to Exhibit 50 in that. That was August of 2019.
And this hearing was when?
April of 2021.
So how much time had elapsed?
Judge, we don't know what happened in between there.
That wasn't my question, was it?
It was not.
Well, then why don't we answer my question and we'll move along from there. So there was a significant amount of time between the prior act of domestic violence and the current trial.
And during that time, my client had actual custody of the child.
Well, the mother did, because the mother, not during that whole period of time.
After the August 17th, right, it was right around that time that mother died. Yes.
Okay. Well, my question isn't time enough, because you say, well, there was no evidence of domestic violence during this period of time. No evidence was presented, and you say, well, we don't know. But the burden was on your client to prove it by clear and convincing evidence.
Your Honor, I think the answer...
And isn't this passage of time also a rebuttal to claims of domestic violence?
It's not in the statute, and that's where the answer is. Now, the substance abuse statute does have a relevant time frame attached to it, two of them actually that I hope to get to, but domestic violence is not. This is a both significant domestic violence and a significant history. Histories of domestic violence do not change by themselves. They require someone to take accountability. They require someone to take action. There was never...
Is that in the
evidence-
statute? Because I missed that part.
It's not in the statute.
Right, you're saying it's reality, but I'm saying, well, passage of time is also something a court could consider in determining whether or not somebody has seen their ways.
It is, but if it were intended by the legislature to be a primary consideration or really any type of consideration, the legislature certainly could have put some time limitations on there as it did with the substance abuse. The substance abuse prong. Efforts to rebut the presumption in the answering brief were in the answering brief, but certainly not in the record. Let me give the court a few examples. The answering brief cites to Exhibit 83 as proof for some sort of rehab or some sort of screening service he went in. Exhibit 83 was never entered into evidence. It also points to Exhibit 89. Exhibit 89 doesn't exist. The exhibit worksheet, I believe it's number 108 in the index of record, it stops at 87. Now, it's clear from the context of the transcript that he's not just confused on the numbers. He is indeed talking about exhibits that are not part of this record. The answering brief also argues that no one can dispute father was clean for 9 months prior to trial. This is where the rubber hits the road. He submitted 4 tests in those 9 months. He was ordered to have submitted between 72 and 90, but he submitted 4. That's less than a 10% compliance rate, and even those tests were not in compliance.
Counsel, what about the statements that are in the answering brief that talk about the modification of the order and the difference in testing schemes between Arizona and California?
The only difference in that order was that it would take place in California. There was no change to the substance of the order. In fact, it was even clarified that he would have to test for fentanyl, and the vast majority of those tests were not for fentanyl.
Okay, counsel, we have evidence, because father clearly testified that he had overcome or made progress on, I think he testified that he did overcome his addiction issues. But I grant that you have these other sections in the record that you're talking about here, but I mean, what's the standard on looking at evidence? I mean, to me, I have evidence coming from this side that says it is, and you have evidence from the other side that says that it isn't. What am I supposed to do with that?
We're to follow jurisprudence. We are to follow the statute. Jurisprudence.
Yeah, that jurisprudence says that when you have a factual issue, that we're supposed to not put our trial court hat on and then retry evidence. Isn't that what the jurisprudence is?
You know, what jurisprudence is, I have cited the court to multiple cases where parental rights were severed for far lesser offenses, for a far...
Is this a termination of parental rights by a DCS seizure?
It's not, and that is my point, that if better testing histories can justify a far greater incursion into parental rights, there is no way that this horrendous testament history cannot even suffice to grant any relief whatsoever.
I think that
under
negates
409.
the issue in a dependency versus an in loco parentis case. When we look at a dependency, there are things in place that help a parent repair their ability to parent. DCS provides services. The oversight of the court is far greater. In this circumstance, we're asked to judge on the evidence presented and accept the factual findings of the court in making our review. So how are we to overcome the court's factual findings in this circumstance?
One, because the court did not follow the statute. The trial judge did admit that the presumption regarding substance abuse applies, but in that case, if he is to find that that presumption is rebutted, he is required to go through several findings, none of which were made, none of which could be made. In fact, the very first finding is to state on the history What establishes it? He doesn't even mention the DUI that happened while the matter was pending. Now, that's a time limitation. There is a 1 year on that the legislature chose to put in this statute that it did not choose to put in the domestic violence statute. What I am asking this court to do is follow something that's common sense in any judicial case. For the sake of jurisprudence, he was ordered to test 8 to 10 times a month. That frequency was never modified. He did not. He did not even come
So we're going to reverse based on a failure to test?
The only other conclusion would be to reward him for his failure to test. And yes, failure to test is in fact grounds. Beyond that, he tested positive for 6 different banned substances. I couldn't find any case in jurisprudence that had that many different drugs. Even the drug that he admitted he was taking, methadone, well, why didn't that, he said he was taking it to curb the craze for the fentanyl. Fentanyl cases are a headline waiting to happen, but he only showed positive for fentanyl in 1 case. Something was wrong with this, and this is where I'm getting into policy. There are going to be some disputed facts about this for sure. But the point is, look at the cutoff on that particular test. He was between 9 and 17 times higher than the rate. That's not even taking it for what he said it was for. I don't believe that any justice can be done in this case without this court going through the full facts. And the full facts, according to Exhibit 67, I cited too few cases. Mr. Riley cited too many. Exhibit 67, there are in fact 28 tests where he was required by court order to have submitted to approximately 200, and that's only through the time of trial. The trial court was also required to consider the results of testing for the last 6 months. What had happened in the last 6 months, the last 9 months actually prior to trial, he submitted 4 and only 4 tests when he was required to have submitted more. If this court is going to be true to those facts, this court has to reverse. Otherwise, all it's doing is rewarding someone who did not comply with an order. I will say...
But isn't enforcement of an order up to the trial judge, not us?
Not when he made a specific finding that father had complied in good faith, and that was the basis. This court cannot condone such a finding. That would be an abuse of discretion. I will save the remainder.
Well, hold on. I have another question for you, and that's if we agree with you that there was some errors here by Judge Brain, does Arizona still have jurisdiction under the UCJEA?
It does.
Because the parent and the child have both lived out of state for how long?
The court does not lose jurisdiction when it goes on appeal. That's the simplest and most obvious answer. The court retains jurisdiction, at least over the appeal. If there's an abuse of discretion...
We don't have exclusive jurisdiction. It says we lose exclusive jurisdiction if the parent and the child don't live in the state. So on a remand, would the court could just simply say, yep, too bad, we don't have jurisdiction anymore, or I'm going to defer to California would be the more appropriate?
That's frankly a question of first impression. There are several such first impression questions in this case, but it only makes sense that this court does not lose jurisdiction while a matter is pending. It's as simple as that. And the court would, when the court, I certainly hope, remands, it would only make sense that the court would retain jurisdiction through the remand. Otherwise, litigants would be able to leave the state and say, the order's appellate proof. Thank you.
Well, you could have filed a special action asking us to stay the order, given in light of what you presented.
That is true.
Okay.
Thank you, Mr. Shields. Mr. Riley.
Good morning. Daniel Riley on behalf of the father, Robert Shafer, in this appeal. The relationship between a parent and a child is an indelible part of our history, tradition, culture, and it enjoys special legal status. The United States Supreme Court has described a parent's right to be a parent and to raise one's own child as, quote, the oldest of the fundamental liberties recognized by this court. In recognition of the special status that the parent-child relationship has, Arizona imposes a heavy burden on third parties who attempt to insert themselves between a parent and child and to claim...
Let's talk about your client, the father in this case. Never really, it was an on-again, off-again relationship with mother. Grandmothers had this child for a significant period of time. Your client engaged admittedly, because he's been convicted in domestic violence and has admittedly engaged in drug abuse. So when we talk about all of those rights, doesn't he have some responsibilities that go along with that?
Of course. And we look at what the status of the individuals were at the time of trial.
Well, let's look at the status of the individual at the time of trial. Your client had not provided any financial support to grandmother to take care of his child during the period he was with grandmother, had he?
That is correct.
Isn't that a responsibility of a parent?
It is, and grandmother
So-
could have asserted a claim for child support.
Okay. And the court did not grant that. Do you concede that she is entitled to that?
No, because she didn't present that claim. It was not presented in her pleadings. It was not, no evidence was presented for that at trial, so she has now waived that issue on
There's
appeal.
a statutory requirement, I mean, not to belabor this, but it's a statutory requirement that we've held that you can't waive.
If it's non-waivable, if the court finds that that's a non-waivable claim, then it could be remanded for calculation of a back support order for the period of time the child was in grandmother's care.
Do you have any, on the domestic violence issue, correct me if I'm wrong, but he said it's not a domestic violence because he can't, who once engaged in it but cannot anymore because the mother had died. If we take that to its logical extreme, if he had killed her, oh, we don't have to worry about domestic violence anymore because she's gone. I mean, that's not the way it's supposed to work, is it?
No, and I don't believe that was a very artful statement that the court made in its ruling. What the case law demonstrates is that the court typically looks at three things to determine whether domestic violence is substantial under the statute. They look at the significance of the incidents, and I concede these were significant things that occurred. The passage of time and its effect, and then the effects on the child. And the evidence demonstrated the child was never present for any of these incidents that had
I think there's
occurred.
conflicting testimony on whether or not the child was present based on the text messages exchanged. Is that not true?
That wasn't the trial court's finding. The trial court found that the domestic violence was sometimes mutual, and there was no finding that the child was ever present for any of these incidents.
If domestic violence is mutual, what does that do to the presumption?
The presumption does not apply when domestic violence is mutual, and that is a legal decision-making presumption, as the court pointed out during the appellant's argument. And this is not a case in which the father was making a claim for legal decision-making. He was possessed of legal decision-making because he was the only surviving legal parent. In the Olison matter, there was a petition between two parents, and that is why the presumption applied in that case. There was an intervening grandparent, but that case started as the father's petition to modify an existing parenting plan, requesting that he be awarded decision-making, because in the prior order he had no decision-making authority. So that is why in that case the court said that the trial court should have looked at the presumptions under 40303, and that's why it doesn't apply here, because this was not a contest between two parents in which a grandparent was intervening as a third party. This was a contest by a grandparent seeking to insert herself between parent and child.
But even if the presumption doesn't apply, you agree that acts of domestic violence are still relevant in determining who should have legal decision-making in any particular case?
Oh, certainly. In weighing whether grandmother had met her burden of clear and convincing evidence, the court was obligated to consider the acts of domestic violence with respect to its effect on the child and father's ability to parent.
You're just saying that because of the three factors that you talked about before, the court had latitude of deciding how much weight to give that in the grand scheme of its analysis? Is that what you're saying?
Yes, and in its order, the trial court was very clear that domestic violence is relevant and it is something to be considered. The court just didn't find the evidence to be particularly pertinent in this case. Because the domestic violence had occurred between two people, both of whom were suffering from substance abuse issues. That relationship obviously no longer exists and is at play here, and the father has now addressed those substance abuse issues that were the underlying factor in the incidence of domestic violence.
When we talk about addressing substance abuse issues, what should this court make of the fact that he was ordered to test on a consistent basis? And if we were to view this in a dependency context and he'd missed the number of tests, we'd be having a different conversation. But he was court-ordered in this case to engage in that behavior and was, I don't even think, minimally compliant in his obligation. The court didn't seem to give any weight to that, but we're required to give a certain amount of weight. It baffles me.
On an abuse of discretion standard, we're looking to see whether there is evidence in the record to support what the trial court found. And the initial order for twice weekly testing was entered based on the incorrect assumption the father was living here in the Phoenix metro area and could report to EverHealth twice per week. When the trial court judge realized that, in fact, he lives in California, it entered a clarifying order stating that he could test in California, but that the scope should be identical to that which was ordered in Arizona. So rather than submit to twice weekly urinalysis, he was submitting to monthly hair follicle tests, which obviously have a much larger window for detecting substances. So the question the trial court was presented with was, did that cover the same scope that the twice weekly urinalysis would have covered? And ultimately, he had completed an inpatient treatment program, was participating in outpatient treatment. The comprehensive custody evaluator opined that his substance abuse disorder was in remission. There was evidence presented from his outpatient treatment provider stating that it was his opinion that father was not abusing fentanyl or any other substances. With that evidence in the record, it can't be said that the trial court abused its discretion in finding that the testing substantially complied with the original twice weekly urinalysis testing. In the 18 months prior to trial, there were 34 tests, 14 of which were hair follicles, the other 24 of which were urinalysis.
Thank you.
There's a simple thought experiment to determine whether or not the statutory scheme being urged by the appellant meets constitutional muster here. In Troxel, the Supreme Court was very clear that the right to be a parent is part of substantive due process. And so you need something more before you can insert yourself into a parent-child relationship.
I'm going to stop you there, and I agree, and I'm very familiar with the constitutional underpinnings of this issue. But I don't think grandmother asserted herself in this situation. I think she was the safety net for both of these parents while they engaged in poor behavior. Was she not?
I would agree with that. The facts bear that out.
And so I was a bit asserting yourself in a parent-child relationship, taking away that parent's right. At this point, wasn't she simply standing in for the safety of the child?
That is absolutely how it began.
And so father just gets to sit back for however many years doing nothing, providing no financial support, and then when he's ready, come in and take the child back because now I'm ready to be a dad?
And I understand that the facts of the case are troubling, but throughout Troxel, the Supreme Court explains that in a competition between a grandparent and a parent, it is not the court's role to engineer what it believes to be in the best interest of the child. That is the standard that is applied in a contest between two parents. Because the parent has a greater constitutional right, the burden in that scenario is for the grandparent to show by clear and convincing evidence that it would be contrary to the child's best interest to be placed in the care of that parent. And that's the thought experiment that can be applied here. Is the position being asserted by the appellant, would that look any different if they were representing someone who is a parent rather than a grandparent? And it wouldn't. One of the first statements that counsel made was that it was father's burden to prove under ARS 403.03 and 403.04. It was his burden to rebut those presumptions, and that's not true. The burden was on grandmother under ARS 409 to rebut the presumption that it is in the child's best interest to be cared for by a parent. And this is addressed in the Troxel case. The Supreme Court in that case said that one of the reasons they were affirming the Washington State Supreme Court case was because the Washington State Supreme Court had explained that the way the trial court did things improperly shifted the burden to the parent to show that it would be in the child's best interest to be placed into the parent's care. And they said that's not how you can do things.
Well, and what you just said may be absolutely correct, but the bottom line here is, if you look at what grandmother was asserting, that father had a domestic violence problem, check, he did. And that he had a drug abuse problem, and check, he did. And isn't the question whether or not, by asserting that, did grandmother prove by clear and convincing evidence that father shouldn't have legal decision-making?
And again, I think it goes back to the question of the facts as they were when the petition was filed and the facts as they were by the time these parties proceeded to trial. This case was pending in front of the family court for a long time, and the family court had two separate temporary orders hearings. It had a comprehensive custody evaluator involved, and throughout the years this case was pending in family court, father did what he could do to try to become a stable, fit parent for his son. He went into inpatient treatment. He went into outpatient treatment and was continuing to participate in an outpatient treatment program. He obtained a steady job. He got on his feet, moved out of his father's house. So he was working on himself during this period. So by the time the parties got to trial, he had demonstrated that he was a fit parent for the child to be placed in his care. At that point, he'd been having unsupervised parenting time with the child under that second temporary order schedule.
But it's not troubling that he said, oh, domestic violence isn't an issue because the person who was harmed is no longer with us?
Yeah, I think what the court said,
Not pertinent is what the court said.
and in its footnote, the court said, the court does not mean to suggest that domestic violence between parents can never be pertinent in such a dispute. Indeed, at its worst, it can form the basis for the juvenile court to sever parental rights under ARS 8-533. So the court was iterating that it was not saying that domestic violence is never going to be pertinent in a dispute between a grandparent and a parent.
But it did in this case.
But under the fact.
Do you believe that under the statute that is a correct statement?
Oh, which statute, Your Honor?
Under all of our statutes governing domestic violence and child custody issues, is domestic violence ever not pertinent in any decision that the court makes regarding a child?
The ARS 25-403.03, I believe it's subparagraph J, specifically states that domestic violence is relevant to the interests of a child. So, of course, the evidence is relevant. That's why it was admitted into evidence. And the standard on appeal is whether or not the trial court abused its discretion in not giving substantial weight to that evidence.
Okay, but you would agree not pertinent is probably not the best way for the trial court to describe its analysis.
I agree.
Okay.
I completely agree.
Except did he even have the right? See, I do find it troubling, I have to admit. He says, yeah, under the statute 403B, we have to consider evidence of domestic violence as being contrary to the best interest of the child. But then he goes on to say, but the goal is to keep the child from being exposed to domestic violence, not to penalize a parent who once engaged in it but cannot anymore. Well, first of all, he can continue to commit domestic violence. It doesn't require that the mother be the subject of the domestic violence. He can commit domestic violence in his current relationship.
I agree completely.
So that statement in and of itself is not completely accurate. And the goal is not to just keep the child from being exposed to domestic violence. We don't like domestic violent people to be raising our children because that perpetuates domestic violence. So in looking at just that sentence, is that legally correct? But the goal is to keep the child from being exposed to domestic violence, not to penalize a parent who once engaged in it but cannot anymore.
I don't believe that domestic violence can be compartmentalized in a person's life. I don't believe that a person can engage in domestic violence and that not somehow seep into the parent-child relationship. I concede that because I believe that. I would not have phrased this order in this way. Again, the question is whether or not the trial court abused its discretion in making that finding, given that there had been a significant passage of time and the child had not been present for at least some, perhaps all, of these incidents. If the court is inclined to remand for...
Hypothetically speaking, before we get there, hypothetically speaking, if the court had said, I find significant domestic violence had occurred, I find that father was the perpetrator of the domestic violence, I find that domestic violence occurred in front of the child, and finds those three factors and says, but it's not significant in this case, would that be a clear error of the application of the law? Because of possibly like the passage of time?
Again, under the case law, the court's looking at three factors: the significance of the events, the passage of time, and its effect on the children. And the case law is not clear how these things are to be weighed, and it's not clear where these elements came from because they're not in the statute. But this is what we have from our case law.
Well, actually, we just cite to it what the trial courts are putting in their minute entries and saying, it's close enough for government work.
Right. It somehow became a boilerplate clause in Maricopa County Superior Court, and now it's just become the standard on appeal. So in weighing those three factors, given the facts of this case, it was certainly significant. There was a passage of roughly 20 months from the most recent incident until the date of trial, and the effect on the child, the child having not been present, but at the same time this was a substantial factor in the child being raised by a grandparent versus being raised by either parent. I may have weighed it differently, but that's not an abuse of discretion. The trial court has broad latitude to determine whether or not something is substantial domestic violence under the statute, and the way I may have weighed it is different than the judge would have weighed it, but that's not a reversible issue. Did your honors have any other questions?
No, thank you.
Thank you.
Thank you, Mr. Wright.
Oh, sorry, you got 54 seconds. Terribly sorry. If we were to remand this case, how would we deal with the jurisdictional issue?
The UCCJEA concern.
At this, we're essentially arguing a moot point, because at this point the grandmother has filed another petition, which the trial court has denied for lack of jurisdiction, because under the UCCJEA, Arizona is no longer the home state. I believe there's also pending litigation filed by the grandmother in California. So I'm really not sure why we're here. I'm not sure what the goal is, because Arizona can't proceed in this case, and there's already pending litigation in California. So I'm
on a grandparent's right?
On a grandparent's rights petition. So I'm not entirely sure what we're doing here.
Thank you, counsel.
Thank you, Mr. Wright. Mr. Shields.
Thank you.
Is that true? Has grandmother filed a petition in California?
She's filed for visitation, yes.
Oh, visitation.
Correct.
So it's not the equivalent of...
To my knowledge, correct. A couple of points of clarification. The exhibit worksheet is actually number 198 on the index of record. Mr. Riley made multiple statements that Luca was not present for any of the domestic violence. That is false. Exhibits 47 and 48 and pages 119 to 120 of the transcript. He was, in fact, there. That deepens the error.
That's pages 47 and 48 of the transcript, you say?
It's exhibits 47 and 48 at trial and pages 119 to 120 of the transcript. Judge McMurdy, you earlier raised that question about the presumptions applying because of his natural right as a parent. I need to point out, he had never asserted that natural right. There was only a paternity order entered after, I believe, the second hearing in this matter, at which point grandmother had already been granted custody. So there is not that waiting around.
Is his name on the birth certificate?
I don't know that. The birth certificate.
And has there ever been a dispute that he's not the biological father?
I can't answer to that either, but the record establishes that the only time he asserted his parental rights was in this matter, at least through what he was required to do by law.
See, I didn't see anybody disputing when he filed the original paternity, the fact that he...
But he had not acted as a father, and if we're speaking in pure legal terms, that comes about only when there is a finding of paternity, which came after my client had already been granted custody. Judge Campbell, you raised on this same question of asserting responsibilities about child support. I'll point the court to page 149 of the transcript. The judge made specific findings that evidence would be submitted for a child support issue. Child support was never granted. This case, for many reasons, is unlike any other. Let me give the court one brief example in closing of how far gone the trial court was, in addition to everything that's been argued. We filed a Rule 83 motion to amend on a couple of issues, including visitation and continuing drug testing. The response admitted, yes, Judge, you should order visitation and you should order drug testing, continued drug testing. Even then, the judge said no. I've never heard or seen of something like that before, where a judge is so bullheaded, pardon my bluntness, that he takes something that even the other side admits to and still won't order it. That gives the court quite a good taste for what exactly is wrong with this order, namely just about everything. My time is up. Does the court have any other questions for me?
No, thank you, Mr. Shields.
Thank you.
Thank you for your arguments. We will take this matter under advisement and issue our decision in due course, and court is adjourned.